It's 3:30. We are missing a few members who are still in Commerce Committee, but they will join us if Commerce Committee ever gets done with their work. Today is the last day to request bill introductions in this committee. We've got a list of them, or at least I have a list of people that I know are going to introduce them. Is Representative Highland here? Don't see him. I'll come back to him. Anyone else on the committee with a request? Okay, if not, Stephen, you're up.
Thank you, Mr. Chairman, members of the committee. My name is Stephen Durst. Appear before you today to request introduction of a bill pertaining to family law, legal custody, and this would be RS number. Apologize, I had this earlier and I sent it to the committee earlier, but I will get that. RS number 2959. Thank you, Natalie. I apologize. Everybody else knew it except for me. And be happy to stand for questions.
On behalf of?
Just a private citizen. If my name works, that's fine.
Mr. Chairman,
Representative Carmichael?
I would have objection if this is a straw man introduction. Mr. Dirk says that this is on behalf of a private citizen. It is not on his behalf. And if he is only appearing here as a straw man to confuse who the real proponent of this legislation is, then I have objection.
Mr. Chairman, members of the committee, Stephen Durst, on behalf of Federico Durst Consulting, on behalf of a client of ours, Mr. Gary Forsey. And again, happy to stand for questions.
Thank you, Mr. Chairman. I will withdraw my objection.
Any questions? Any objection? We'll get that introduced. Thank you. Eric Stafford.
Thank you, Mr. Chairman and members of the committee. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber of Commerce, here with a request to introduce RS 3044 on behalf of us, the Kansas Hospital Association, the Kansas Healthcare Association. It is an extension of the COVID liability protections that passed, I think, twice last year in House Bill 2126 and Senate Bill 283. Would extend it to January 20th of 2023, just like House Bill 2477 has passed earlier this session.
Any questions? Objection? Get that introduced. Thank you.
Thank you.
Kevin Barone.
Hello? Yeah, there we go. Kevin Barone. I'm here on behalf of the Kansas Bail Agents Association introducing RS 3021. And it's a bill dealing with conditions of release.
Any questions or objection? We'll get that introduced. Thank you
very much.
Next, ks.
Hello, Lee Keck with KDADS. I would respectfully request introduction of 22 RS 3032, and this expands options for competency evaluations and restoration.
Any questions, committee, or objection? We will get that introduced. Is Mike Fonkert here with Appleseed? If not, on behalf of Kansas Appleseed, I will request RS 3025, and this puts into effect provides for a payment plan for fines, fees, and court costs. Any question or objection? We'll get that one introduced. Anyone else with a request? Going, gone. Come back next year. Okay. Oh, hold on. Oh. Yeah, hold on. Okay, on behalf of Representative Highland, I will request RS 2864, which has to do with tort reform. You have any questions? I don't have answers to them. Any objection? Okay, we'll get that one introduced as well. We will now move on to our hearings. I'm going to open the hearing on House Bill 2556 and 2557 at the same time. Many or most of you that have signed up as proponents are listed for both, and as some have used almost the identical testimony as the bills are quite similar. So when I call you up, feel free to address both bills at the same time. We will do all proponents and then do questions at the end. So you don't have, we won't do them one by one. We'll see what questions we have at the end and then go back to whoever we have questions for. So I'll start with Natalie and have her give us an overview of these two bills.
Thank you, Mr. Chairman. House Bill 2556 prohibits the denial of a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. And then House Bill 2557 prohibits the denial of a petition for expungement of a juvenile adjudication due to the petitioner's inability to pay. And it also authorizes expungement if the juvenile has not committed an offense in the previous 2 years. So if we go back to House Bill 2556, Section 1 amends KSA 124516. That's the expungement statute for municipal court records. Subsection H is amended to provide that the court shall not deny a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. The petitioner's unwillingness rather than an inability to pay could be considered as a factor in denying that petition for expungement. Subsection I is also amended to provide that if expungement is ordered, the petitioner shall continue to be responsible for fully satisfying any outstanding costs, fees, fines, and restitution. For the purpose of collecting that debt, the clerk of the court, a contracting agent, the petitioner or the petitioner's attorney, the beneficiary of an order of restitution, and any other person authorized by the court would be able to have access to that expunged record. And then a new subsection M is added to provide that the determination of when the person satisfied the sentence excludes the payment of costs, fines, fees, and restitution. Section 2 amends KSA 216614, which is the expungement statute for district court records. Essentially, all the same changes that were made in 124516 with respect to municipal records would apply at the district court level for those expungements. Over in House Bill 2557, the bill amends KSA 383212. That's the expungement statute for juvenile offenders. Current law there requires the court to order expungement if the court finds that since the final discharge of the juvenile has not been convicted of a felony or misdemeanor other than a traffic offense or has been adjudicated as a juvenile offender. This bill would change that to require the court to order expungement if the juvenile hasn't been convicted or adjudicated of a felony in the previous 2 years. And then the bill also provides that the court shall not deny that petition for expungement due to the juvenile's inability to pay. The petitioner's unwillingness rather than an inability to pay would be able to be considered a factor in denying that petition. And unless the court orders otherwise, in this case, expungement shall not release the juvenile from the obligation to pay those outstanding costs, fees, fines, or restitution. And I can take any questions.
Do we have any questions for Natalie on either bill? Representative Carmichael.
Thank you. And I want to make sure we're on 2575, is that correct?
No, we're on 2556 and 2557.
I apologize, I was asleep at the switch. Thank you.
Okay, thank you, Natalie. Beginning with proponents, Ron Wirtz. You're up first, Ron.
Thank you, Mr. Chairman, members of the committee. I'm testifying on behalf of the Kansas Judicial Councils and the Kansas Judicial Council's Criminal Law Committee, as well as the Juvenile Offender Committee and Sync Committee, which produced, the latter which produced 2557, and 2556 was proposed by the Criminal Law Study Committee. Currently, under the adult statute, 2556, There's a waiting period. That waiting period, it varies, depends on the offense, 1, 3, 5, or 10 years. And it begins when the sentence is, when the defendant has satisfied the sentence which is imposed. Many judges read that to include the requirement that they pay fees, costs, the financial obligations that go along with it. This creates a circular problem. The person can't get a job or has difficulty getting a good job because they have the prior conviction. That complicates their ability to pay, and so you have a circular issue. What this bill would do is allow the person to have the expungement, but it would preserve the bills that are still pending, and they could be collected as a civil debt, and they would not be discharged. In the Criminal Law Committee, as you see, if you've seen the report, is quite a diverse group. It involves a KBI director, retired chief of police, law professors, assistant attorneys general, prosecutors, defense lawyers. Representative Wheeler has also been a member of the committee for now about 3 or 4 or 5 years or so, and participated in this one. It was really very uncontroversial. And so even the bill collectors have suggested that this is a good idea because people are able to get, if they make money, they can pay their bills, very simply. And that's the simple premise. If a person should be obstreperous and not be paying the bill because they're just ornery, the judge can still withhold expungement based on that if there's a showing of intent in that respect. So it's not that non-payment cannot be considered, it just can't prevent the expungement because of a person's inability to pay. And that's a simple honing of the bill, and there didn't seem to be any objection to it. This is the same bill that was introduced or was heard last year in the Senate committee. It just didn't get the turnaround time, didn't hit turnaround time in time, so it died in the Senate. So it's been reintroduced here with a minor tweak that was suggested by Office of Judicial Administration. Otherwise, it's the bill that the Judicial Council proposed. 2557 is a tweak of the Juvenile Bill. It was brought up when we were studying 2556, but those of us who do not practice, and there weren't many of us on the criminal committee who practice regularly in juvenile court, decided that it would be best looked at by the experts in that committee. So it was forwarded to the Judicial Council and then referred to that committee. And they came up with the changes which are embodied in 2557 and were explained by the reviser. Currently, there's a big difference or a significant difference in when a person can have their juvenile offense expunged. Adults have the right to have it expunged if they haven't been convicted of a felony or don't have any pending in a 2-year period. They are then eligible to be expunged. The juveniles, the way it can be read, and fairly read, the way it's written, the juvenile cannot have the adjudication expunged if there was a felony or a misdemeanor at any time. And therefore, it's been changed to conform to the adult statute, which is no felonies within the last 2 years. And so it limits it and gives them the same level ground. It also makes it very clear that the rules on collection of debts would be the same for the juveniles as the adults. They could not be denied expungement because they owed the money. and the court would keep its power to excuse the payment, but it would not be excused without a specific order. And that's the difference between the way it's presently written and as it's proposed. So the Judicial Council supports both bills. We would request your favorable consideration.
Thank you. Next, we have Marilyn Harp.
Hi, I'm going to reserve most of my comments for 2575, but just to say that I am familiar with a young man who was, I should say Marilyn Harp, Kansas Legal Services, sorry. We worked with a young man who was, on one unfortunate day of his life, arrested for shoplifting cigarettes in Derby. He was both taken to juvenile court and found later to be a juvenile offender and charged in the Derby Municipal Court with possession of tobacco. At age 30, he was still unable to deal successfully with the expungement of the much more serious juvenile offender charge because the Derby expungement process for his misdemeanor possession of tobacco as a 17-year-old was difficult for him to manage. And so the volunteer lawyer who was working to help him get that promotion and deal with his conviction, which concerned his employer a great deal, was unable to accomplish that. This bill would solve that problem, the juvenile offender bill. Thanks.
Thank you. Now I think oh no, maybe we're in person. Michelle Ewart.
Thank you, members of the committee. My name is Michelle Ewart, and I'm an associate professor of law at Washburn University, where I teach the civil section of the Washburn Law Clinic. My students and I do a lot of expungement cases. That's a big part of our practice. I also serve on the board for the Board of Indigent Defense Services, and in a prior life, I was a legal services attorney. So I spent a lot of time working with low-income individuals who are trying to improve their family circumstances. I want to make clear that I'm here today in my own capacity, and that the testimony I give is my own and not reflecting Washburn's position on any of these issues or BID's position on any of these issues. So expungement of past criminal records is a really critical tool in helping people access employment or housing. People with a record are more likely to be not even given a first interview for jobs and more likely to be not considered good potential tenants. And so what this means is there's an impact not just on the petitioner themselves who might want an expungement, but on their family as well. To qualify for an expungement of a conviction, the petitioner has to show a couple of things. First, that their circumstances and behavior warrant the expungement, and also that expungement of that conviction would be consistent with the public welfare. And that's what we do when we tell our clients stories in court. We show how they are not the person now who they were when they were convicted. So they're doing things like volunteering in the community, pursuing their education, taking on leadership positions in their faith institutions, repairing relationships with their family. Those are all good things. We want them to be able to use that to improve their circumstances. The problem is, as Professor Wirtz testified to earlier, courts are currently interpreting completion of a sentence to include having paid off fines and fees and restitution. So what I am seeing with my clients is they're able to expunge some charges where there were no fines owed, but not others. And what this means is the impact of that other expungement is diluted if these other charges are still on their record. And so ironically, people who would most benefit from expungement are unable to access this important tool. So they're having a harder time getting jobs and getting housing. With these two bills, HB 2556 and 2557, everyone wins. The petitioner wins if they are able to expunge records so they can get better jobs and employment. Their families win if the breadwinners are able to get better jobs. The courts win because they're actually more likely to collect on fines and fees and restitution if someone has a higher paying job. And society at large benefits if people are better able to support themselves. So I thank you for your time. I am happy to answer any questions at the end, but I urge you to vote favorably on this bill. Both bills, actually. Thank you.
Thank you. Eileen Burquist. Eileen might, oh, there she is. You were written on one and here on the other, so come on up.
Hello, thank you so much for having me here today, Chair and Committee. I believe that many of the points that I was going to make were already made by people who already have a lot of this experience, but I would like to underline that poverty should not be a barrier to justice or to success in our society. These bills give people an opportunity to truly put their pasts behind them, and I believe that that's something that many people can get behind. I would also like to point out that for juveniles especially, court debt can be especially crushing. This is something that follows them well into their adult years. And whatever your feelings about whether it is just or right to impose court debt on youth, I think giving them the avenue to have this expungement and still carrying out their responsibilities is a really great way to give them just a chance in this world. So I'm happy to stand for questions at the appropriate time.
Thank you. Christina Kersey, and she is online.
Hi, Mr. Chairman, can you hear me?
I can hear you, yes.
Great, thank you. My name is Christina Kersey. I am the Senior Youth Defense Counsel with the Galt Center, which was formerly the National Juvenile Defender Center. And I just want to thank the committee and the chairman for having me today. The Galt Center urges you to look favorably upon House Bill 2557. I've submitted testimony, so I don't want to be repetitive, only to say that this bill is in keeping with the Kansas Purpose Clause, which talks about the improvement of a youth's ability to live more productively and responsibly in the community. We know that the collateral consequences of youth court extend well past fulfilling all of their obligations, and that this can impact their education, housing, employment, and their community engagement. We urge you to consider the following amendments to strengthen the bill, which would be eliminating the $176 docketing fee, consideration of deletion of the consideration of circumstances of behavior, and also unwillingness in addition to the inability to pay. We believe that those two conditions are subject to bias and arbitrariness, and that they're vague. Additionally, we would ask that you consider providing counsel to youth in all post-dispositional settings, but including expungement. Prior to coming to the Galt Center, I was a frontline youth defender for 18 and a half years in the state of New Jersey, proudly. And what I was able to do was put together petitions and briefs and applications for expungement in less than an hour. And I had young people that had waited 10 years past being eligible for those expungement merely because the process was confusing and difficult for them. So we just really want to stress the importance of access to counsel in post-dispositional settings, including expungement. We believe that these additions are in line with the intent of the bill, which is to give second chances to a defined category of people, not lead to arbitrary results or a chilling based on finances or because of confusion of procedure. I'm happy to stand for questions, and I thank you for your time.
Thank you. Next, we have Lindsey Smith, also on WebEx.
Good afternoon. Can everyone hear me okay?
We can, yes.
Great. Thank you so much, Mr. Chairman, members, for permitting me to testify and testify remotely. My name is Lindsey Smith. I'm a lawyer at the Juvenile Law Center. We advocate for rights, dignity, equity, and opportunity for young people in the juvenile justice and child welfare systems. We've published 3 major reports on juvenile records, as well as 1 major report on fines and fees imposed on youth. We've testified before Congress, state legislatures across the country on these issues. So I just want to, first of all, strongly support the passage of HB 2557 in particular. And then based on our research in this area, I wanted to suggest a couple of changes to the committee. These are based in the evidence, based on what research shows about expungement and what works for young people. In the big picture here, as some folks who have gone before me have said, the purpose of expungement is to help young people meet those key milestones that really help them become successful, that promote public safety, And so this bill is especially important for those young people. And I just want to take a moment to note that the juvenile system is supposed to be different. The purpose of the system is to make sure that a young person is not marked with a permanent stigma of criminal conviction based on something they did as a child. And so these amendments I propose specifically for the youth context. The first is, as Ms. Kersey suggested, there's currently a $176 fee for young people who want to expunge offenses that they committed as children. So $176 plus an additional $19 surcharge, almost $200. I would suggest that the committee remove this fee. I think it's in line with what you all have already recognized, which is that no person should be denied expungement based on wealth. There are all these problems that come up when you have these records. Harder to get a job, harder to get occupational licenses, and to ask a young person up front to pay $200, even to get in front of the courts, is just not something that is going to promote the goals of this bill in the bigger picture. In one kind of fact that sticks out to me a lot is that nationwide, 60% of families with a child in the juvenile justice system have an income of less than $20,000. 60% under $20,000. So the majority of folks in the system are already living in poverty, and that $200 could place this whole beneficial process out of reach for them. The second amendment I propose is removing that language about unwillingness to pay. And that's specific to the juvenile context here, because kids for the most part can't pay. They're legally and practically unable to work. We want them to be focusing on school, focusing on successful engagement in probation, in court programming. And then the records themselves are preventing these young people from access to jobs. There is a 50% reduction in callback rate or an interview rate for a person who has a record versus someone who does not. So coming out the gate, by thinking about unwillingness in the context of children, there's just very few situations to which that would apply. And it's going to use up a lot of scarce judicial resources to ask courts to make those inquiries. It's very fact specific. Mr. Wirtz mentioned the showing of intent that a young person would have to make or defend against, but they don't even have a lawyer at this point. So you're asking someone who might be a teenager still, who might be in their early 20s, to navigate a complex system, make this fact-intensive inquiry without access to counsel. And then there's the risk of this justice by geography. Judges in different areas might see ability to pay versus willingness differently. And so I think there's just the cost-benefit trade-off is not worth it in the juvenile context. And then finally, we'd recommend that the committee look into automatic expungement for the same reason that young people don't have access to lawyers at this stage. So there are very few young people who are actually filing for expungement in Kansas because of this lack of access. And we think that should be for all offenses. For young people who have adjudications for more serious offenses, those young people are currently totally excluded from expungement of juvenile records. And one reason we suggest expanding that to cover all offenses in this context is that if a child is adjudicated delinquent for a serious crime, that means they were already in front of a judge who decided that that child belongs in the juvenile system and not the adult system. They deserve this juvenile level of accountability and not this permanent stigma of criminal conviction. And then second, the data just shows there's no correlation between the seriousness of an offense in juvenile adjudication and the risk of recidivism. So it's not actually supporting public safety to exclude young people based on these offenses. And because of the risk of, and in fact, denying young people access to employment and housing can cause increased recidivism in the future. So thank you very much for this opportunity to testify. I'm prepared to stand for questions, and I would again encourage the committee to pass this bill forward with these suggested amendments.
Very good, thank you. Next, I have Jamie Kavanaugh. Jamie's also online.
Good afternoon, Chairman Patton and members of the committee. My name is Jamie Kavanaugh. I'm an attorney with the Institute for Justice. The Institute exists to protect personal freedoms and individual liberties. We work both legislatively and through litigation to fight for a decrease in fines and fees and to ensure that government at all levels is using the fines and fees appropriately. For example, in 2019, we won the landmark case Timms v. State of Indiana. And in that case, the U.S. Supreme Court announced that the Eighth Amendment's protection against excessive fines is indeed incorporated against the states. So I commend the committee for considering this bill. I'm testifying on behalf of 2557, the Juvenile Bill. It's an important acknowledgement of the fact that a juvenile conviction should not be a lifetime sentence. After completing a sentence, an ex-offender shouldn't be worrying about whether their criminal record is going to interfere with finding work, finding housing, or applying for an occupational license. So I support the bill strongly, and Institute for Justice does, but I'd like to make 2 points about how the committee might improve the bill. First, I'd encourage the committee to consider the fact that many states have made expungement automatic. It's sort of like an administrative process. So laws in states like Michigan, Pennsylvania, Utah, and Virginia set out specific criteria, just like this bill. And in those states, if a petitioner meets the standards, they will have their petition granted automatically. So this process ensures fairness for all petitioners. Expungements shouldn't hinge on a judge's temperament, especially in a state like Kansas, where many judges are elected. Second, the court should not consider a petitioner's willingness to pay court debt at an expungement hearing. Expungement of a conviction does not erase any court debt automatically, and the standard for consideration about a petitioner's unwillingness to pay is discretionary and vague. The problem with this is that it could lead prosecutors or courts themselves to impose a burden, a positive burden on the petitioners to prove that they are willing to pay or prove that they haven't been unwilling to pay. And this is just another barrier that would prevent ex-offenders or petitioners, from being able to seek expungement, and that's against the will of this bill, which is to open the doors wide and allow juveniles to seek expungement. So I'd ask the committee to consider these 2 suggestions, but regardless, I support HB 2557. Thank you.
Thank you. Committee, we have written proponent testimony from Kansas Appleseed and Children's Alliance of Kansas. Anyone else as a proponent for either of these 2 bills? Okay, committee, now let's do questions for the proponents. Representative Carmichael.
Thank you, Mr. Chair. I recognize, I think from the testimony of the conferees, that currently in order to obtain an expungement of a juvenile conviction, there's a $176 docket fee plus a $19 surcharge, not to mention whatever it costs to hire a lawyer. But I'd also like to know what kind of fine, from practitioners in Kansas, maybe they can tell us, what kind of fines or docket fees do juveniles run up so that happy 18th birthday, you owe $500 in fines and $200 in docket fees? Or what kind of money are we talking about for this financial burden that juveniles carry with them even into adulthood and beyond, perhaps to the grave for all I know?
Any takers? Come on up.
Thank you again, committee members. Michelle Ewart. So just to clarify, there are 2 issues. There's the issue of the filing fee, that $195, which is the $176 docket fee plus the $19 judicial surcharge. That is routinely being waived. I have never had a client had to pay that because my clients are all indigent. So this question then of what are the fees and fines and restitution that is a barrier, I have seen it anywhere from multiple cases of $50 or $60 to multiple cases of hundreds of dollars to more than $1,000. And so depending on how many charges the individual is trying to expunge, we're talking about potentially a lot of money when people are having to make choices about rent and keeping the lights on and buying food and paying for gas and stuff like that. And so for many people, it is a quite significant amount of money. Thank you.
Representative Schreiber.
Thank you, Mr. Chairman, and I'm not sure who would want to answer, but I'm curious about the fees if they aren't paid. Is this a situation where they set up a payment plan when the expungement occurs? But if they fail in that plan, what happens, or are there garnishments? How does that collection of fees work? Thank you.
Marilyn Harp, Kansas Legal Services. Like people who aren't seeking expungement, it is possible the collection folks work to collect that. Many counties have agreements with the collection firm to go after fines and fees, and specifically, these bills allow that, even though it's expunged, to allow those folks to continue to have access to those records, so that that method of collecting fines and fees could go on. People can voluntarily make payment plans, of course, or take money in. There's no specific way of dealing with that, although I believe one of the bills that that was introduced today would set up a method for payment plans specifically on that, but that's not for hearing today. But I think that the bill that Appleseed asked to be introduced at the start of this hearing does look at the issue of specific payment plans. There's not a process for that.
And are they eligible for garnishment? I mean, at some point, is that option as well?
Absolutely, okay. They're eligible for garnishment, and it's not it happens. It happens with some regularity.
Thank you. Thank you, Mr. Chairman.
Representative Wheeler.
Thank you, Mr. Chair. Ma'am, could you come back, please? Just for a quick question for you. These fees that we're talking about could be court costs and things like that, but are we talking about restitution as well?
In the bill as presented, the word restitution is included, and that was considered and was part of the specific language in there. And so the Judicial Council folks considered that and understood and made arrangements for folks in the case of restitution to seek to seek a civil judgment. I mean, it's not a civil judgment. It is still a judgment in the criminal case that can be garnished on. They don't have to go elsewhere, but it does include restitution.
And if I may, one more from Mr. Worsley. We discussed this in the committee, and that is the civil collection issue, which would leave expungement records open for review by civil collectors.
Yes.
And the risk. Now, expungement of convictions are sealed unless it's, say, a private investigator or a security clearance or something like that. But I'm not sure that we really included protection for the person whose conviction is expunged from exposure by the civil collector.
The bill does not, you're correct, the bill does not specifically say that the bill collector has to keep this private and undisclosed. It would have to be, under the current situation, in the contract with the court to maintain the confidentiality that's there. I don't know if they were to dox out somebody in order to try to collect a bill, it should be governed by the bill collection procedures, the rules for bill collectors, the fairness in collection. I'm not a bill collector lawyer, but there's a fair Fair Collections Acts that would involve.
Not every judicial district has that civil collector, and some rely upon private.
And most of them do, I think. They go out to private, they refer the bill to private collection agencies. This bill provides that they can have, those private collection agencies can have access to the file after it's been expunged for the limited purpose of collecting the information. If you read the bill the way we read the bill, it would be limited information that can be given out. But of course, by necessity, they would know what the conviction was and that the person still owes money.
Thank you, Mr. Chair. Thank you, sir.
Any additional questions for the proponents? Okay, we will move on to neutral. And we have one, John Goodyear.
Thank you, Mr. Chairman, members of the committee. Good afternoon. My name is John Goodyear, and I'm General Counsel with the League of Kansas Municipalities. Giving neutral testimony today specifically on House Bill 2556, and even more specifically just to Section 1 of the bill affecting municipal courts. So the League is supportive of efforts to help address cycles of indigency, poverty, and when that leads to recidivism. That said, whenever legislation like this comes up, we're wary of provisions that eliminate methods that help to ensure compliance with our statutes, our ordinances, and our court decisions. Looking to House Bill 2556, however, it's our belief that the bill will preserve those necessary compliance measures while helping certain petitioners to get back on their feet. Section 1 of the bill, like I said, is the one that affects our municipal courts. It amends those statutes and prohibits the court from denying petition for expungement because of inability to pay. It's important to our members that upon expungement, the petitioner would still be responsible for fully satisfying any obligations, and whoever would need access to those records in order to collect on those obligations would have that. Further, we are supportive of the distinction that's made between inability to pay versus unwillingness, still allowing the court to deny an expungement request if a petitioner has the ability to pay but has chosen not to. And here we get to the reason for our neutral testimony on the bill. This provision may need to be fleshed out a little bit. How does a petitioner demonstrate that they are willing but unable to pay? Perhaps it would be worth it to put in a provision that says maybe when they file that petition, they are required to submit some sort of sworn statement or an affidavit of indigency. Further, just some questions regarding the timing of when these petitions could be filed came up as I was reading the bill. Subsection M of the bill now excludes payment of obligations when determining whether or not someone has fully satisfied their sentence. So the question then becomes if a fee, fine, if that was the only part of the court's order, would the clock start on the day of the order? So that might need some fleshing out and some clarification. Mr. Chairman, that's all I have for my testimony today. We would ask that as the committee considers this bill, that those questions get talked about, discussed, and maybe answered with the bill. And Mr. Chairman, I'll stand for any questions that the committee may have.
Committee, this is the only neutral conferee I show. Anyone else here is neutral? If not, any questions for John? Thank you.
All right, thank you.
I do not have any opponent testimony. Anyone? Yeah, Representative Heiberger.
Chair, with your permission, I have a technical question for Natalie.
Sure.
2557, page 3, line 18, refers to being adjudicated as a juvenile offender under the revised Kansas Juvenile Code for a felony. It seems to me that in that sense, we usually refer to an act which, if committed by an adult, would be a felony. Is that inaccurate, and if not, is there a reason for the difference?
Mr. Chairman, Representative Heiberger, we do typically say that. We would say adjudicated as an offender, as a juvenile offender for an offense, which if committed by an adult would constitute a felony under the revised Kansas Juvenile Justice Code. It looks like, I don't know the last time the statute was amended, and I suspect that this provision has been in there for a long time, so it might be before we started doing that. I could certainly do, a technical amendment, but I don't necessarily think that a court would interpret that any different. It's just kind of a drafting style thing that we do.
Okay, no opponents? I think that's where I was at. Then I will close the hearings on House Bill 2556 and House Bill 2557. We'll move on, open the hearing on House Bill 2575, and have Natalie come back up to give us an overview.
Thank you, Mr. Chairman. House Bill 2575 requires certain records to be automatically expunged from a person's criminal record. The bill would enact a new section of law that would provide that if a court enters an order of acquittal or dismissal of criminal charges, the court would order the record of such charges and related arrest records expunged 30 days after such court order is entered, unless the person objects to the expungement or an appeal is filed. If an appeal is filed and the appellate court issues a mandate affirming the district court's dismissal, then the district court would also be required to expunge those records 30 days after the mandate's filed. An order expunging records shall not require any action by the person. So this would be for criminal records going forward, and the provisions here in subsection A1 would not be retroactive. The rest of the provisions that I'm talking about would be retroactive for people's records going back. So a person who's been charged with a criminal offense and acquittal or dismissed and whose records have not been expunged may petition the court in which the disposition of charges was made to expunge all charges and related arrest records. That petition would have to be filed not sooner than 60 days after the order of acquittal or dismissal. And the provisions of paragraph 1 and 2 would not apply to diversion agreements for a violation of driving under the influence. After a petition is filed, the court would notify the prosecutor and provide them with an opportunity to respond. If the prosecutor objects, then the court would set the matter for hearing, and the prosecutor would be required to notify the victim. If no objection is made, then the court would order the expungement of the records 30 days after the filing of the petition. If the court finds the petition is properly filed, the court shall grant the petition and order the records expunged if the court finds that that would be consistent with the public welfare. An order of expungement under this section would expunge all criminal records in the custody of the court, any criminal records in the custody of another agency or official, including law enforcement records. When a court order for expungement is issued under this section, the clerk of the court would send a certified copy of that to the KBI. The KBI would then notify the FBI, the Secretary of Corrections, and the appellate courts and any other criminal justice agency that might have records related to that individual. If the case was appealed from municipal court, then the clerk would send a copy to that municipal court. After the order of expungement is entered, the petitioner shall be treated as not having been arrested, charged, acquitted, dismissed, or diverted of the crime, except upon conviction of another crime. A diversion that was expunged could be considered as a prior conviction for determining a sentence, and it also would be able to be considered for certain applications for licensure, the same ones that we retain expungement records for currently. An appellate court that issued an opinion in the case shall order the appellate case file be sealed, and any version of the opinion on the court's website would have to be modified to avoid use of that defendant's name. Except for the disclosures required in subsection C for those licensures in an application for an employment, licensure, or other civil right or privilege, a person whose record of arrest, acquittal, dismissal, or diversion that's been expunged would be able to state that that person has never been arrested, charged, acquitted, dismissed, or diverted of the crime. A person whose record has been expunged would be deemed to have had such person's right to keep and bear arms fully restored. When records are expunged under this section, the custodian of those records would not be able to disclose the existence of the records except as requested by certain entities for authorized use there in that section. As used in this section, criminal charges do not include traffic infractions that wouldn't otherwise constitute a misdemeanor. And then like I mentioned earlier, all these provisions except for that automatic expungement would be retroactive. And then section 2 amends KSA 216614. That's the current expungement statute to remove references to diversion agreements. So those would now be expunged pursuant to this new section of law. And I can take any questions.
Any questions for Natalie? Representative Wheeler.
Thank you, Mr. Chair. Thank you, Natalie. What kind of objection to an automatic expungement would you contemplate could possibly be successful under this statute?
Well, there could be, if they didn't file, if they filed too early, then you would be able to make that objection. I'm not sure what other type of objection would be contemplated there.
Is a judicial finding by a court or a jury of not guilty equivalent to a factual finding of innocence?
No.
So a person could be not guilty by verdict, but still be guilty as the Dickens by fact.
Mr. Chairman, I suppose that's true. This would apply, though. So if a jury does acquit someone, then that acquittal would be eligible for this automatic expungement.
The one that I'm thinking about is more where a material witness disappears and the case is dismissed, or they can't produce the witness to prove guilt beyond a reasonable doubt.
Sure. Yeah. So in that case, Mr. Chairman, that would be expunged here automatically. If there's no conviction, this new section doesn't cover automatic expungement of convictions. You would still have to go through that process. But if the charges were dismissed or you were acquitted, then those records would be automatically expunged and any associated arrest records.
Thank you.
Any other questions for Natalie? Representative Curtis?
Thank you, Mr. Chairman. So Natalie, is there a period of time, like when the records, say you get a list of records that are to be expunged, is there a period of time then that the prosecutor can object? Would that be, so they could say that that person's should not be automatically expunged?
Let me look for the timeline. I believe that the prosecutor, I want to say, has 30 days to file that objection, but let me double check. Yeah, so if you look at the bottom of page 1, starting at line 35, after that petition is filed, the court is then required to provide notice to the prosecutor. The prosecutor has an opportunity to respond, and then it says such response shall be filed within 30 days after the filing of the petition.
Representative Carmichael.
Thank you, Mr. Chair. All right, help me figure this out because I'm now confused. If we have a circumstance where the prosecutor's case falls apart for whatever reason, maybe at a prelim because of the lack of credibility of a witness, or maybe because a witness couldn't appear to testify in person, as I understand it, the prosecutor, upon the impending expungement of the arrest, can go to the judge and say, Judge, we're going to be refiling this. We have credible evidence. Here are affidavits from people who will testify. And even though this case was dismissed, we don't believe there should be an expungement at this stage, at least in the proceedings. Is that the way it works, or am I missing an automatic expungement step, if you would?
Mr. Chairman, and certainly there's some practitioners in the room who will be able to expound on that right now. We don't have automatic expungement of this right now. So the way it would work currently would be, if those charges were dismissed, then that person would have to go and file for expungement of those arrest records. If the prosecutor refiled, then I assume that would be a different court number. So you'd have a whole different set of records. So you could still get expungement of that original dismissal, but then that subsequent case, if they did end up refiling, would then go forward.
I guess I'm not tracking. I'm not talking about how it works under the current law. I'm talking about how it would work under this bill. We passed this bill. Does the prosecutor have an opportunity to say, wait a minute, no expungement here. My case fell apart at prelim because they didn't believe Annie, but I've still got Mary and Joe. They're going to come the next time we file this case, so please don't automatically expunge this arrest.
Mr. Chairman, I'm not sure that would be, I mean, I think that if that were to happen, then the prosecutor would have to refile those criminal charges. So I believe that
Of course, the prosecutor has to refile the charge. I'm talking about expungement, automatic expungement of the arrest when the case has to be dismissed because the prosecutor failed in his or her proof at a preliminary hearing, for example.
That I would have to look at how that would work because that arrest record would be associated with both of those criminal cases. So you wouldn't want it completely expunged if they did end up refiling. I would have to do a little bit more digging into that question.
I see a well-experienced prosecutor sitting right behind you, ma'am. I'm sure he's going to enlighten us. So maybe it would be best that I reserve any further questions pending the district attorney's testimony. Thank you, Mr. Chairman. Thank you, Ms. Scott.
Any other questions for Natalie? Okay, thank you, Natalie. Moving on to proponents. Come on up. Mr. Dupree, you're first one on my list. Lucky you.
Mr. Chairman, members of the committee, thank you. I appreciate the compliment. Don't know how truthful it was, but I will try to answer your questions. One of my favorite quotes to this that comes to mind is, I do not count myself to have apprehended, but one thing I do is reaching forward to those things which are before. I'm the district attorney of Wyandotte County, which is the 4th largest county in the state of Kansas, and I just so happen to be a Pentecostal preacher as well, and that was a quote by Apostle Paul. When we're talking about expungements are simple. They give individuals an opportunity to reach forward and to forget those things which are behind. I can go on, but some of the most wise folks who spoke on the bill previous gave all of the stats and gave the numbers. I will tell you that before becoming the district attorney, for about a decade, I was a defense lawyer, both in the public defender's office as well as in private practice with my lovely wife. And during that time, we charged anywhere from $750 to $1,500 per expungement. Expungement simply gives individuals who have paid their debt to society an opportunity to move forward. They've paid their debt. They've done what the law said that they should do and how to do it. And once they're done with that, it gives them an opportunity to reach forward, to try to get a better job, to try to get better housing, to take care of their families, to become a law-abiding citizen, which is what we as prosecutors want them to become, because it costs money to charge individuals. It costs money to try individuals. Recidivism is real, and the number one reason why individuals commit crime is because they lack the ability to move forward. Economics and education. That's the remedy to preventing crime. If you can give individuals an opportunity to provide for themselves, they're less likely to try to take yours. Will it prevent all crimes from happening? No, but it's a great start. I want to reiterate the fact that we're not talking about individuals who have not paid their debt. They've paid their debt, and now they're trying to move forward. This specific bill deals only with not guilties, diversions, and dismissals. What that means is if an individual is charged with a crime, and just like Representative Willer said, if the state cannot prove beyond a reasonable doubt, and they can't move forward in a preliminary hearing, and the case is dismissed, then that individual would have the opportunity to have an automatic or automated expungement. So within that 30-day range, let me tell you how it goes at this point. At the end of a conviction, let's just jump to the end after jury trial happens, your judge stands up, you've been convicted. The judge says to the individual, when this case is done, and 3 or 5 years have passed, you then have the opportunity to receive an expungement and you can consult a lawyer. What I see in a situation like this, where the case is dismissed or it's a diversion or it's an acquittal, the judge can simply say, in 30 days, this case is going to be expunged. That, Representative Carmichael, gives the prosecutor an opportunity and gives us notice to object if we want to. You have dismissal with prejudice, and you have dismissal without prejudice. Dismissal without prejudice, I would say, falls into the category that we spoke about, where a witness is missing and the prosecution and law enforcement needs a little bit more time to get their case together. And so at that point, we could object and say, Judge, we plan on refiling this. So that expungement at that point can be halted by the state. And the judge then gives the opportunity to us and, of course, to make the decision. Now, if the case was dismissed with prejudice, which means that the court, upon its own accord, said, yes, Mr. Prosecutor, Mrs. Prosecutor, for whatever reason, you, as judge, I'm taking your opportunity to refile this case. So you can in no way refile this case. At that point, they still, again, would have that opportunity within that 30 days for it to be dismissed. So the prosecution would be put on notice right there within that 30 days, which if we go to how it is right now, it's the same situation. The only thing that changes is that we're not waiting on someone to petition to the court, thus then the court giving us notice that someone is asking for expungement. But it also takes away the very thing that many of these folks spoke about earlier, which is that $195 filing fee that individuals have to pay. $195 is a lot of money to someone who is struggling, who's indigent, who can't find a job, and who will not get the call back because of the criminal record. So I am for this bill. I think it would be best for the citizens of the state of Kansas, for the citizens of Wyandotte County. We have done an expungement fair every year for the last 4 years. We've expunged well over 400 individuals who we connected with multiple organizations, including the Kansas Legal Services and the Community College, to find grants to pay for this $196 fee. These individuals need an opportunity. And I finish with this. If everyone else has the opportunity to press forward, let's give those who can't afford it the opportunity to. I will stand for questions at the appropriate time.
Very good, thank you.
Thank you.
Next, we have Jermaine Wilson.
Thank you, Mr. Chairman and members of the committee. My name is Jermaine Wilson, and I'm currently serving as the Mayor Pro Tem of Leavenworth, Kansas, but I am not here to represent Leavenworth. I am here as a citizen in support of this bill. In 2007, I was convicted of possession of narcotics, a severity level 4. Because I had a criminal background in the juvenile system, I was sentenced to 40 months in prison. During my time of incarceration, I had a son who was 8 months. I didn't want my son to follow into my same footsteps, so I became a Christian. I became a believer of Christ because that was the only way that I found hope during my time of incarceration. I started taking programs that was offering me leadership skills, that was also teaching me fatherhood. So many programs that was being offered to me, I took advantage of those services, including reentry programs. But when the prison doors opened up, I wasn't faced with the obstacles, it really became reality to me how much hardship and the challenges I really had to endure. Many employers turned me down for employment because I had a criminal record. I applied at every fast food restaurant inside of Leavenworth, but I was denied because I had a criminal conviction. I had to settle for a job in Grandview, Missouri at a Pryor Cleaners making $8.50. It was a 1-hour drive and my transportation wasn't really that reliable, but I worked that job faithfully because they gave me an opportunity. That job lasted 6 months. When my person that I was riding with, when that was no longer reliable transportation, I had to let the job go. I worked with many employers that gave me an opportunity because I had the skill set, but they paid me under the table just because they didn't want to be known as the company that hired a convicted felon. I got released from prison December the 9th, 2010. After I ended up working dead-end jobs, struggling to make ends meet, I was finally blessed with an opportunity to work at Ken 2 Services on Fort Leavenworth. I worked that job faithfully for many years, and in 2014, my supervisor informed me. She said, if you do not get your government clearance, we are going to have to terminate you because Fort Leavenworth have just enhanced their security, and anyone who has a criminal conviction can no longer work on this installation. I prayed, I cried, I looked up and see when I was eligible to get my criminal record expunged. The year 2014, I was eligible to get my record expunged. But the challenge that I was faced with now, no resources. I didn't have the funds to get my criminal record expunged. I found a lawyer who said he's willing to do it for $500. There was a $190 filing fee that was associated with that. And so I just reached out to my supervisor and I said, please give me some time. And so I was blessed and fortunate to be able to receive income tax. And so my pastor was my homeowner, and he allowed me the opportunity to be able to use my tax money to invest in my freedom, which allowed me to get my criminal record expunged. It was $700. A lot of people don't have that. I know there's a filing fee associated with it, but there's so many lawyers who charge for this. And I was faced with the $700 that I had to give up, but I knew it was worth the investment in my future. Once my criminal record was expunged, so many doors had opened up for me. I was blessed with with employment opportunity. I was blessed with the option of being able to find better housing. And I was just given so many opportunities in my community. The prison system even opened up and allowed me to be able to go back and share my message of hope and redemption. I don't know why, but God called me to get involved in the politics. And I prayed. And I said, God, what is it that you want me to do? And he said, I am calling you because I want you to give hope. I want you to be able to provide second chance. And I want you to be able to share your story so the decision makers can see they are not only investing off into a person who needs a second chance, but they're investing off into an individual's future. Each one of you all hold the keys to be able to open the doors to purpose that are inside of each one of us. And so when I signed up for politics, I prayed. God allowed me to go through the process. I was successful. I received the most votes, and I became the city commissioner of Leavenworth, Kansas. And because my commissioners loved me so much, they appointed me in the year 2019 to serve as the mayor of Leavenworth, Kansas. I was inspired by my good friend, the prosecutor, Mr. Mark Dupree. Just the progressive when it comes to the progress in reaching forward and creating second chances and opportunities for those who needed a brighter future. He inspired me to connect with our prosecutor, Mr. Todd Thompson, and we provided free expungement to those individuals that was eligible inside the city of Leavenworth. And when individuals signed up for this expungement, the first 30 people literally had non-violent offenses, and they were working at fast food restaurants just because they had to settle. They didn't have the resources to be able to pay off the expungement fee that was associated with it, including with the lawyer. And so when we provided that free expungement to those individuals, it really opened the door to so many individuals who were able to get a new start in life. If God didn't allow me to be able to get my criminal record expunged, I would not be here today. So I want to say to you all, please, 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 just know we serve a God of a second chance who's given us all hope. We all made mistakes in life, but if we're in a position of power to be able to provide those second chances like God has done for each one of us, let us all reach forward and make a difference in somebody else's life. God bless you.
Next, we have John Jinks.
Good afternoon, Mr. Chairman and members of the committee. John Jakes, Director of Public Policy at the Greater Kansas City Chamber of Commerce. Standing here today in support of HB 2575. Mr. Pro Tem Wilson did a great job, and Mr. Dupree did as well. So not too much to add, but as many of you know, the KC Chamber has been in the criminal justice space for 3 or 4 years now, and we really got into it for 2 reasons. One, to lower recidivism and crime in our communities, but 2, really, is to expand the eligible pool of workers or available talent for our businesses. Currently in Kansas City, the greater Kansas City area right now, there's about 92,000 job openings available. At this time last year, it was more like 50,000. It's just incredible how many jobs are out there. And it's really the number one need that we hear from our businesses. Tapping this pool of justice-involved individuals is just one more tool in the toolbox that our employers can access to grow their available talent pool. And also, there's a study out there from the chief economist at Fifth Third Bank that marginalizing justice-involved individuals has cost the GDP across the country $400 billion with a B annually. Bills like this are just one more opportunity for justice-involved individuals to get employed or to no longer be underemployed. And states around the country, red and blue, have had a lot of success in passing this type of legislation. So that's all I've really had to say. The KC Chamber supports HB 2575, and I'd be happy to stand for questions at the appropriate time. Thank you.
Thank you. Marilyn Harp.
Marilyn Harp, Kansas Legal Services. I want to focus on what is a very narrow bill here. It first of all might surprise you to know that there's no clear way for people who have been found not guilty or have had charges dismissed to expunge those records at all. That is because the expungement law speaks about a period of time from the date of conviction or completing the sentence. And when there's nothing like that, it's not clear when the time runs. And so this bill would provide a clear time frame for that. The other thing we need to realize is that we are at a point in time when public access to records in many parts of the state, and in about 3 years when the public portal, the court record system comes online in every part of the state, is as easy as sitting at your desk and going and looking it up. So people who who asked for, paid a fee, and were diverted from conviction of a crime for doing certain things will suddenly find those court records, despite a dismissal, fully available to the public, not by going to the courthouse, but by sitting at the personnel office desk to go look it up. Will those HR directors look down to the bottom to find that the case was dismissed? It's my contention that they won't. They'll find the conviction, they'll find the charges were filed, and that will lead to employment prospects and housing prospects diminished for people who were never convicted of a crime, but rather paid the fee and participated in a diversion program. That is a portion of the people that this bill is designed for. The other group of people are people who are acquitted of the charges, so dismissed and acquittals. There ought to be a way for those people to have the public's view of their record sealed. So that's what this bill is about. It is an automated process because that is a group of people for whom it should be relatively simple for the court system to determine who they are and have a court form which takes the action of, in an automated way, of sealing from public view those records. I want to speak to Representative Carmichael's question specifically, and that is about cases where a prosecutor might be seeking to refile charges. Under this bill, those dismissed charges would be sealed. However, unlike current expungement law, where access of a prosecutor back into those records is limited only to the specific circumstance where a prosecutor is seeking prior convictions for a sentencing, prosecutors would have full access to those records if they were intent on refiling those charges. So nothing about this law would prevent prosecutors from having access to the arrest, investigative, and prior court records in those cases, even though those cases would fall into the public sealing of those records. I'll stand for questions later.
Thank you. Next, on WebEx, we have Ross Henry Stewart.
Can you hear me?
Yes.
Great. Chairman Patton and the members of the committee, thank you for having me today. My name is Ross Henry Stewart. I'm a practicing attorney in Kansas City, and I handle lots of expungements. I have a defense firm here in Kansas City. I'm based in Westwood, but I live in KCK. I'd like to thank DA Dupree and I'd like to thank KLS for their testimony about this, also because they have expungement fairs, which is a great thing to be doing for the community. I've volunteered at them before, and I think that's really needed. The access that this bill is going to give people is going to keep them from needing my practice as much as they do now, and I frankly think that's great. If we're allowing people to move on with their lives without having to pay me, hundreds of dollars or thousands of dollars to go do an expungement, not to mention the filing fee being $195 and some change typically, keeping that from being a barrier for people so that they can go and move on with their lives, so they can go get rental houses, loans, apartments, certifications for jobs. The amount of expungements I do for people that are looking to better themselves and go do something else with their life after something bad had occurred is pretty large. So lots of people want to go become nurses, people want to become doctors, people want to get a CDL, people want to get some sort of licensure for the job they have, whatever it may be, so they can move up in that job, but this is holding them back from that background review. Getting that off their record and having that be automatic would be a great help to lots of people who are looking to move forward with their lives and have new opportunities and grow as individuals. And frankly, that's why I love doing expungements, is because you're helping people down the road to get away from things that were mistakes in the past. So I unequivocally support this bill. I really hope that it goes through, and I'd stand for questions later if you have any. Thank you for your time.
Next, I have Eileen Burquist, but I think Eileen stepped out, so we'll just treat hers as written testimony. I have quite the list of written proponents. Grissom Miller Law Firm, the Wichita Regional Chamber of Commerce, Overland Park Chamber of Commerce, Healthy Community Wyandotte, Kansas Appleseed, Kansas Interfaith Action, Kansas Coalition on Sexual and Domestic Violence, and the Unified Government of Wyandotte County, Kansas City, Kansas. Anyone else as a proponent in person or online? Okay, committee questions for proponents. Representative Carmichael, then Wheeler.
Thank you, Mr. Chairman. First, I greatly appreciate the testimony of my old friend Marilyn Harp in pointing out to us that we really don't have an expungement law for those who stood wrongly accused, those who were charged and found not guilty. So I'm really glad that we have this, but my question is for Mr. Dupree, if he's still handy there. I can't see the full room, but I trust he hasn't left yet.
He's on his way up, Representative Carmichael.
Okay. To start into my question, Mr. Dupree, I think you've told us that you are the district attorney for the fourth largest county in Kansas, that you prosecute crime. But I'm very concerned with what I see in the written testimony of the Kansas County and District Attorneys Association. And I wanted to make sure you, as a prosecutor from one of the largest counties in the state, had an opportunity to comment upon at least the KCDA's written testimony. The area that concerns me is in the second full paragraph where they explain to us that 2575 is before us today and that it applies to court records, related arrest records, even where there's or if a court enters an order of acquittal of criminal charges or enters an order dismissing with or without prejudice. Then the County and District Attorneys Association goes on to say that with respect to those circumstances, the KCDAA is adamantly opposed to legislation which creates automatic expungements of thousands of offenses annually instead of leaving the burden on the defendant to petition the court and prove they have moved away from their prior behavior. I'd like to know from you, sir, how someone who's been acquitted of the crime or the charges have been dismissed, who entered the legal system cloaked in the presumption of innocence and left the courtroom still cloaked in the presumption of innocence, how and why, how in the first place, and second, why, should they have to prove that they have, quote, moved away from their prior behavior? When they're innocent, they're presumed innocent, the state has failed to prove them guilty, the charges have been dismissed. Help me understand that, Mr. Prosecutor.
Representative Carmichael, this is one of the very reasons why I stand in opposition to my dear colleagues with the Kansas County and District Attorneys Association. And it makes no sense. There is no other way of saying it. In this country, everyone is innocent until proven guilty. And if, in the court of law, they are not proven guilty, then they get to walk away as an innocent person. Unless the Constitution has changed, and unless this country has changed, if a case has gone forward and you have not been convicted or the case is dismissed, you should not have to prove anything. At the end of the day, we as prosecutors in 1939, the United States Supreme Court says that prosecutors of the United States of America are ministers of justice. That means that our job as prosecutors is to make sure, one, that the guilty not go free, but two, that the innocent not suffer. Hence meaning, I present to you that my job embodies the fact of making sure that those who are innocent do not have to prove a doggone thing. And so I oppose my dear brothers and sisters in the organization, as I did last year, and I still do. And I think in the interest of justice, this is exactly what our founders were talking about concerning this criminal justice system.
Mr. Dupree, I certainly hope that our mutual friends in the Kansas County and District Attorneys Association pay careful admonition or pay careful heed to the admonition of our Supreme Court regarding what their duty is, because I fear from this testimony they may have forgotten that duty. Thank you, Mr. Chair.
Representative Wheeler.
Thank you, Mr. Chair. Mr. Dupree.
Yes, sir.
You may or may not know that I retired as a prosecutor elected after 20 years. You may not know that, but prior to that, in full disclosure, I, not as a public defender, represented high-level criminal defense for 24. The nature of my questions does not mean how I feel about this bill. I just want to clarify.
Yes, sir.
The examples that you gave in your original statement all applied to preliminary hearing or before where jeopardy had not attached. There's a marked distinction between when jeopardy attaches in a dismissal and when jeopardy has not attached and there could be a refiling. We agree on that, right?
Yes, sir.
Now let's address the jeopardy attaches, which is the real tough one. because a case can be dismissed for many reasons that have truly nothing to do with guilt or innocence. But under our law, if it's dismissed with prejudice after jeopardy, it's over, correct?
Correct.
This bill or not, it's over. The question is, can you get that expunged? That's the issue we're dealing with.
Yes.
Now, I keep hearing, and you're going to have to help me on this because I've been out of the business for almost, I can't do the math. Back when I was prosecuting and defending, when you applied for expungement of a conviction, you applied within the original criminal case and there was no filing fee. And you're saying that's different now?
Yes, sir. And
I do want you to know that I'm ancient.
I am holding my comments, and I will simply agree that things were different back whenever it was. With all due respect, right? And so, but now, sir, it is a filing fee of $195 that you have to file for the petition in order for a court to even hear your request for expungement.
That's wrong. I'll just make that statement. And I have some others, but I think I just want to quit, Mr. Chairman, and thank you very much for your testimony. And Mr. Wilson, thank you very much for your testimonial. It was inspiring.
Representative Heiberger.
Thank you, Mr. Chair. I think Representative Carmichael's questioning did what I would have attempted to do with Mr. Dupree by pointing out that someone who is acquitted is presumed innocent in our judicial system. But I would like to thank Mr. Dupree, Mr. Wilson, and Mr. Stewart for pointing out that I haven't been charging enough for expungements.
Any other questions for proponents? Okay, we'll move on to neutral. We have one present, Marissa Bayless.
Good afternoon, Committee. Marisa Bayless, Deputy Special Counsel to the Chief Justice. I'm here to provide neutral testimony on 2575. We actually just are proposing 2 changes, and I've attached them to my testimony. The first one's on page 2, line 19. We discussed this bill with our appellate clerks, and they just requested clarifying the language on the requirement that the KBI, right now it says shall notify the respected groups. We just request striking that and adding the language that the KBI send a copy of an order. That's not a new duty imposed on the KBI. Generally, they send a copy of orders when they do send us notification. So we're just trying to memorialize that practice right now. The second proposed change is actually page 4, line 2 on subsection D. So this section, as proposed in the bill, would require the appellate court to seal its case file and also direct that the version of the appellate opinion on the court's website be modified to avoid use of the defendant's name in the case title and the body of the opinion. So we're just asking the committee to consider striking this section. We do understand the purpose behind this is to ensure that an individual after an expungement is not associated with the case, but we think that this provision might not guarantee that. By the time the expungement has been ordered, these opinions have likely been collected by Westlaw, LexisNexis, and then other like free legal websites like Cornell. So we're just asking not to have 2 dueling opinions out there for clarity's sake. We have spoken to both Representative Curtis and Ms. Harp and believe these are friendly amendments.
Any questions, committee? Look online. Okay, thank you.
Thank you.
Committee, you also have written neutral testimony from the Kansas Judicial Council, and just, well, I encourage you to read it. But you'll recall last year we had a hearing on House Bill 2226 towards the end of session or right before turnaround, before some deadline. And Representative Curtis and I visited about that, and so we asked the Judicial Council to look at it. And so read their testimony, because this bill is at least they did not introduce the bill like they did the first two, but the recommendations came from that committee. We'll move on to opponents. We have one on WebEx, Darren Davini.
Thank you, Mr. Chairman. Submitted the written testimony, and thank you for your opportunity to provide this testimony to you today with regard to House Bill 2575. This bill would amend 216614 to create automatic expungement of court records related arrest records. We've dealt with these issues. At this point, the committee knows what is at stake. At this point, I've submitted the written testimony. I did want to highlight on the second page of that testimony, however, something that I think requires clarification. And this is predicated upon Representative Carmichael's questioning. But our membership is in full support of those persons who are arrested or charged with criminal cases and later acquitted, or whom their cases have been dismissed due to innocence, being able to have those records expunged so they don't create issues for them in the future. The highlighted portion of the written testimony in paragraph 2 was referring to a defendant, and this gets back to Representative Wheeler's comments in which we were talking about whether jeopardy has attached. I've included an example in the written testimony with regard to, at least the example that I gave was dealing with a global plea agreement situation where there might be a defendant who's charged with 4 cases. Between the prosecutor and defense attorney, a deal is negotiated where possibly a defendant pleads guilty to 1 or 2, possibly 3 of the 4 cases, but yet another case might be dismissed. This is triggering automatic expungement and a purging of any and all arrest procedures of that 4th case, for instance. Now, that 4th case might be a traffic offense, and the first 3 cases might be serious person crimes or serious property crimes that need to be addressed and that would possibly merit a prison sentence as a result. So consequently, that 4th case, by dismissing it, you're avoiding additional court costs, you're avoiding additional burdens on a defendant in dismissing that. And certainly in those cases, to just trigger an automatic expungement as a result of that seems to be unjust. So as a whole, 2575 it's not, the entirety of this bill is not a terrible idea. And the KCDAA and I join my colleague, Mr. Dupree, with an idea that innocent people should not be suffering through the system. Those that are acquitted should have some advantage, but in this case, what we have is an automated function of the court, and it gives a 30-day window for a prosecutor to apparently have the wherewithal to determine whether or not a case that does get dismissed for a lack of evidence needs to be refiled, can be refiled, and I can certainly enumerate situations where that's not really possible. That 30-day window is simply not long enough, and this automated feature, I think, is going to lapse in the ability to adequately prosecute or consider refiling of charges that sometimes are quite serious. Quick example might be one of domestic violence, in which the victim refuses to come to court and requires therapy or needs after the case is filed. That can sometimes take months, and as long as it's refiled back within the statute of limitations, prosecution can go forward in the instance of domestic violence. I can probably give a number of different examples, but at this hour of the day, what I'll defer to at this point is the written testimony as submitted and answer any questions of this committee.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. And Mr. Davini, I think I can speak for this committee that even though the hour is late, we do not mean for you to limit your testimony on this important issue in legislation simply because there were many others who testified before you. So I'm sure that the committee is willing to take additional time to hear your testimony in full today because it's important. That being said, I want to make sure I understand the position of the Kansas County and District Attorneys Association. It's your position that even though a defendant has been found not guilty by a jury of his or her peers, and they've reached that decision by a unanimous verdict, that the Kansas County and District Attorneys Association maintains that person may not be truly innocent. The jury may have made a mistake, And therefore, that person who arrived cloaked in innocence leaves cloaked in innocence with a presumption of innocence. In the Kansas County and District Attorneys Association's opinion, they ought to have to go back to court and prove to the judge that they're actually innocent. Is that really your position, sir?
No, it's not. Mr. Chairman, Representative Carmichael, I would, obviously that's not the position that KCDAA or I would take as a prosecutor of 22 years. What I suggest to you is even prosecuting cases, when we're talking about expungement, we're talking about the eradication of the arrest data, the police reports, the record as a whole. And there are oftentimes, and domestic violence battery is a reasonable situation that I've come across a number of times, where an individual, you have two parties that are constantly seeing arrests out of their home by somebody that's beating a victim in a domestic situation. They might have 6 or 7 cases out of municipal courts, district courts, possibly multiple jurisdictions. Not every one of those cases results in successful prosecution, but it is tantamount in looking at the number of arrests and contacts with law enforcement to determine a pattern of abuse, an MO that's going to be valuable not only for review, but if these records are expunged and eradicated, we lose our ability to look back in history to see if there's a potential for conflict. Now, if every one of those cases results in acquittal, I guess, in looking at some situation like that, then certainly you'd question whether or not to file that case. But the lack of access to that information, being able to look at that, doesn't give a prosecutor a fair assessment of what it is that he's looking at in order to protect the victim of that domestic violence under those situations.
Unless I misunderstood Ms. Harp, I think the two of you have a serious disagreement about what this legislation does, because I think what she indicated to us is that the investigative records are still there, that you can use them. But, sir, I'm terribly concerned about your proposition that when someone has been found not guilty by a jury of their peers, that you can still use that arrest for some sort of purpose, or even worse, in cases where your case fell apart, say at a preliminary hearing and the judge dismissed it, that you think you ought to be able to treat that person like someone who was essentially adjudicated by the judge. And it's just contrary to my understanding of the way the system of justice works in the United States, but very consistent with the way I understand the system of justice works in the People's Republic of China, and it concerns me.
Mr. Chairman, if I can respond to that briefly. Again, the dismissal of charges, and that can be without prejudice, prior to any adjudication or finding of not guilty, respectfully to this committee, the use of that information and this purpose to refile won't be available or won't be able to be accessed because it will have automatically been expunged under the drafted HB 2575. That's the objection that KCDA has to this bill, and that is that the automatic expungement provision is too quick, and it doesn't take into account the fact that many cases can be refiled and resubmitted at a later date, and it's going to be in excess possibly of 30 days.
Additional questions? Okay, sorry for the delay there. Representative Curtis.
Thank you, Mr. Chairman. So if I could ask Mr. Davini, do I have his name correct? Is that
Davini.
Ask Mr. Davini if he's still, did he go off?
He's still here. We just don't see him on the screen.
Okay, I just can't see him. So, Mr. Davini, you indicated that your main objections were that it was too quick and the look back at records. Is that correct?
Yes, essentially.
Okay. So, too quick. What are we talking time frame?
Well, the ability to refile that case certainly would come under the statute of limitations for that part, for the offense for which those charges may arise. I would suppose I didn't really come up with an alternative plan or an alternative draft of 2575, but it is not uncommon for a PC, a probable cause arrest to be made on a drug defendant, for instance, and if we're waiting for lab results for confirmation of those drugs, it could be that the case is dismissed and have to later be refiled upon verification, in which case that's generally in excess of 30 days down the road. If they're, obviously the statute of limitations is going to apply differently for felonies for misdemeanors, but again, the premise of an automatic expungement as a result of this for all is concerning to the KCDAA with regard to how it might interfere with us being able to refile and reaccess those records.
And I don't know if the chairman plans to work our bill, but would you be willing to sit down with me and have this discussion?
I'd be happy to, Representative.
Okay, I think I reached out to you last week, so perhaps we can get together this week.
Very well.
Representative Heiberger.
Thank you, Mr. Chair. The way I read this bill, and please tell me if I'm reading it wrong, that I'm looking specifically at section F4 on page 4 of the bill, which states that whenever the records of arrest, acquittal, dismissal, conviction, etc., have been expunged under the provisions of this section, then they shall not be disclosed except when requested by, go down to section 6, a prosecutor for the purpose of a potential prosecution. Is that not accurate? I mean, does that not address the situation?
Mr. Chairman, is that a question to me? I'm sorry, from the representative.
Yes, you're the only person on the stand right now, so.
Very well. My apologies. One of the concerns I have is about the record keeping. The statute seems to imply that the expungement would allow for all records to be kept, and that, but yet these expungement orders exist. Again, I can speak to the statute to the extent it does say that a prosecutor has the access to these records. Whether or not they can actually be utilized for prosecution or later determinations seems to be a question mark. And if further deliberation with one or more of the committee members at a later time would assist with us fleshing this out, if I'm mistaken, I'll own my mistake. But I think there are still complications by this 30-day automatic expungement provision.
Any additional questions? Okay, thank you, Darren. That's it. So let's close the hearing on House Bill 2575. Representative Curtis and Representative Wheeler, very unofficial working group. If you two can get with the neutral and opponents and try to come up with something, keep me posted. I would like to work all three of these next week. So see what we can do, come up with something. No extra pay, no extra pay. Committee, we have 2 hearings tomorrow. Wednesday, we have 2 hearings. On Wednesday, I would also like to try to get caught up on some of the bills that we didn't get worked last week. That list has changed a little. I've taken one off because the Senate appears to have moved a similar bill out of committee, so we're going to save the blessed shell for now. So 2496, 2527, and 2537 is the list I gave you last week. And I think I've mentioned that I would like to work 2154 and 102, both bills that we heard. Well, one of them we even worked last year. So 2154 and 102 at some point this week. If we have time on Wednesday, I'm hoping to do that on Wednesday. And then we'll have another list of bills for Thursday that I'll get you as we get closer to Thursday. That's it for now. We'll see you all tomorrow. We're adjourned.